120 words per minute. Get ready. Start. As per learned counsel for the opposite party number 4, that is the state project director, Sarv Shiksha Abhiyan, there is no permanent post available in this scheme, and for running the scheme the funds are being provided by the central government and the state government. Stop. He has further submitted that so far as the retiral dues and other things are concerned, there is no provision for payment of the same and no budget is provided for the same. Stop. Since, the Sarv Shiksha Abhiyan is not a permanent government department, therefore, retiral dues, etc. may not be paid to the employees of the said scheme. Stop. This is the reason to the employees working on contractual deputation basis only for the time being. Stop. This is the main reason for repatriating the petitioner Sir Void Order dated 30th 1 2018 to their parent department, that is, the basic education department. Stop. On the strength of the aforesaid submission, learned counsel for the opposite party number 4, Sri Anand Mani Tripathi, has vehemently submitted that order dated 30th 1 2018 is perfectly legal and justifiable, and the bunch of writ petitions are misconceived and the same may be dismissed. Stop. In support of his submission, Sri Anand Mani Tripathi has cited the judgment of Honorable Apex Court in Kunal Nanda versus Union of India and another, within bracket 2000 bracket close 5 SCC 362, referring para 6 of the aforesaid judgment is being reproduced herein below. Stop para. On the legal submissions made also, there are no merits whatsoever. Stop. It is well settled that unless the claim of the deputationist for permanent absorption in the department where he works on deputation is based upon any statutory rule, regulation or order having the force of law, a deputationist cannot assert and succeed in any such claim for absorption. Stop. The basic principle underlying deputation itself is that the person concerned can always and at any time be repatriated to his parent department to serve in his substantive position therein at the instance of either both of the departments, and there is no vested right in such a person to continue for long on deputation or get absorbed in the department to which he had gone on deputation. Stop. The reference to the decision in Rameshwar Prasad versus MD, UP Rajkiya Nirman Nigam Limited. Stop. And others, 1999 within bracket 8 bracket close SCC 381, is inappropriate since, the consideration therein was in the light of statutory rules for absorption and the scope of those rules. Stop. The claim that he need not be a graduate for absorption and being a service candidate, on completing service of 10 years, he is exempt from the requirement of possessing a degree need mentioned, only to be rejected. Stop. The stand of the respondent department that the absorption of a deputationist being won against the direct quota, the possession of basic educational qualification prescribed for direct recruitment, that is, a degree is a must and essential, and that there could be no comparison of the claim of such a person with one to be dealt with no promotion of a candidate who is already in service in that department is well merited and deserves to be sustained, and we see no infirmity whatsoever in the said claim. Stop para. The crux of the aforesaid para is that a deputationist cannot assert and succeed in his claim for permanent absorption in the department where he works on reputation, unless his claim is based upon any statutory rule, regulation or order having the force of law. Stop. A deputationist can always and at any time be repatriated to his parent department, at the instance of either borrowing department or parent department. Stop.